First speaker is Peter Laurijssen. He is joining us from Antwerp, Belgium. Peter has degrees in law and philosophy from universities of Namur, Leuven, and Leuven-la-Neuve. Also degrees in shipping and freight forwarding from Antwerp, and qualifying examinations from Institute of Chartered Shipbrokers in London, 2002. He is very active also in the Belgium Maritime Law Association, currently serving as vice president, and also in the CMI, where he is the member of the International Working Group on the Recognition of Foreign Judicial Sales of Ships. He is the winner of Clarkson's Award for Dry Cargo Chartering and winner of Maritime Policy and Management Award for Economics of Sea Transport and Maritime Trade. And very important, he is also editor-in-chief of European Transport Law, and I am repeating Peter's offer to all speakers in the colloquium on judicial sale. If they wish, they can prepare articles and publish them in the European Transport Law. Peter will be happy to give you instructions for authors. Also, Peter is representative of International Chamber of Shipping and BIMCO, and in that sense he voices the interest of the shipping industry in UNCITRAL Working Group 6. The title of his presentation is UNCITRAL Draft Instrument on the Judicial Sale of Ships, What's in it for the Shipping Industry? Peter, please, the floor is yours.
Thank you, Igor, for the kind introduction, and I hope that everybody can hear me and see the presentation on screen.
Yes.
Okay, super. So the title of my presentation is a question. This draft instrument, what's in it for the shipping industry? The answer, you might think, is very obvious, or it might be far from obvious. And in the beginning, there was a lot of misunderstanding and misconception between ship owners and ship owners representative organizations with respect to the draft instrument, the Beijing draft, and then the work which was being done by the UNCITRAL. So that's why I chose this title. Here we go. Earlier this morning, we got a very extensive introduction by Anne into how the CMI Beijing draft came into existence, so I'm not going to repeat all of that. As we know, the draft was finalized firstly in Beijing in October 2012 at the CMI conference, which took place in that city. And there were amendments in Dublin in 2013 and in Hamburg in 2014. After the Malta colloquium, which was nicely documented with pictures by Anne, UNCITRAL put the draft international convention on the foreign judicial sale of ships and their recognition on the agenda. That was in June 2018. And as from then, the project was on the agenda, and we had 2 sessions already in Working Group 6, Judicial Sale of Ships. The 35th session took place in New York last year. November last year, we met again in Vienna for the 36th session. And we are hoping to have a new session of the Vienna session in November this year soon. Good. Okay. Angelo this morning already gave a view and an introduction into the working procedures and the workflow within UNCITRAL. That was very clear. I have nothing to add to that. Maybe one small point, that is that ICS, International Chamber of Shipping, and BIMCO, that they are attending to the meetings as they are NGOs, so non-governmental organizations. They represent ship owners or ship owners organizations, and they attend to the meetings of the UNCITRAL Working Group as an observing member. So apart from the members of the UNCITRAL Commission, the permanent members, there are other states who have an observer status. There are governmental organizations who have an observer status. And as to myself, I was representing 2 non-governmental organizations in the working group to express the ship owners' concerns and to make a contribution on behalf of ship owners. How are we organized as ship owners? Well, we are all organized nationally. Each country, or most countries, probably landlocked countries don't have any, but most other countries have their national ship owners organizations. And to name a few, we have Japanese Ship Owners Association, Armateurs de France, and a number of other ones. Here in Belgium, we have the Royal Belgian Ship Owners Association, who also has a keen interest in the project. The national ship owners organizations, they are regrouped in supranational and intranational organizations. On European Union level, we have EXA, which is the European Community Ship Owners Association, who's also following this instrument and the developments with great interest. And their members are the national ship owners associations of most EU countries. On the other hand, we have ICS, that's international, and there we have national associations worldwide who are member of the International Chamber of Shipping. BIMCO, on the other hand, is a bit of a different animal. It's not an association of ship owners organizations, but it's an association and their membership consists of individual shipping companies. Now, BIMCO from that perspective is not a small fish, because if you count the tonnage, the ship tonnage owned by all members of BIMCO, if you add it together, you come somewhere in the region of 86% of all tonnage floating on the world seas, which is represented by BIMCO. So just wanted to give you that background so that you have a bit of an idea of what ICS and BIMCO are about. In the sessions of Working Group 6, it's actually ICS, International Chamber of Shipping, who takes the lead, and they are acting in concert with BIMCO. International Chamber of Shipping is concerned with international law, international public law. They also are permanent members of the International Maritime Organization. Whilst on the other hand, BIMCO is more dealing with the private law aspects of shipping and of maritime law. I think to most of you, BIMCO is known because of its documentary work, all the documents, standard documents, contracts in the shipping industry, which they prepare, standard time charters, bareboat charters, barcons, sale forms for the sale of ships, etc. So for them, this draft instrument, which is a little bit borderline between private law and international law, because it is a convention and it has typical form and structure of a convention, but it has a great impact on a private law relationship between players in the maritime industry. So that's a background which I certainly didn't want to spare. I have embellished my presentation with a few pictures of ships, of course, as being a ship owner. Port of registry, home port of this ship is Antwerp, which is also the home port or the home hub of CMI. CMI, which in Antwerp in 2 years' time will celebrate its 125th anniversary. And hopefully by that time we have a fully finalized instrument on the judicial sale of ships. And hopefully we can all invite you in Antwerp then to come and discuss this beautiful instrument, which is being prepared by UNCITRAL. Good. So what is the ship owner's angle to the draft instrument? Well, first of all, if we look at the aim of the draft instrument, and especially the considerations which were made by Working Group 6 in New York in 2019, we see that there is a need, an urgent need, a pressing need for an international instrument, because there is a great lack of legal certainty. Legal certainty with respect to, on the one hand, the acquisition of clean title. What that is has been explained by other speakers already today. So there is a great lack of legal certainty, both with respect to acquisition of clean title and also as to the ability of the purchaser to deregister the ship following a judicial sale. That has also been highlighted by Merle in the discussion this afternoon, in her presentation this afternoon, because certain documents are needed and cooperation is also needed from the outgoing registry for a ship owner who buys a ship in a judicial sale, to have it registered, to have a flag on the ship, and to trade the vessel, and in the end to make money whilst trading the vessel, because that's the whole purpose, of course, of owning ships and operating ships. Now, this lack of legal certainty reflects not only on the ship owners, but also on the financiers, on ship banks and ship leasing houses, and in fact, to all providers of maritime services and crew. So there was a consensus that the work of UNCITRAL and the scope of the draft instrument should really focus on the issues of clean title and deregistration. And this with the Beijing draft prepared by CMI as a basis of discussion. So that's how we set off in 2019 in the first session. The aims of the draft instrument as set out by the working group is also or corresponds to a large extent with the aims as put forward by CMI at the time. So failure in some jurisdictions of recognition of foreign judgments which order the judicial sale, and consequently the impossibility to register the ships and to commercially trade the vessel without maritime claims, without arrests after the judicial sale, and to what huge and actually incredible situations that can lead was very conveniently illustrated by Anne at the end of her presentation this morning. That also illustrated quite well the extra delays and the costs, the expenses that can arise for all parties which are interested in the judicial sale. As a consequence of all these difficulties, uncertainties, lack of legal certainty, there is also a very limited interest in ships which are being sold judicially, and that's a point that I will also touch upon later during my presentation. Likewise, for the fact that ships which are sold in judicial sales are generally sold at a great discount as compared to the actual market price of the ship. So from a shipowner's point of view, there is a loss of value, you could say destruction of value, simply by the fact that a ship is being sold in a judicial sale rather than in a private sale. And then the consequence, of course, is that there is a limited payout of dividends to the creditors. So these are all, I would say, deficiencies and consequences of the lack of international uniformity, which are aimed, or which we aim to eliminate by this draft instrument. Now I started my presentation, and the title of my presentation was a question. So what's in it for ship owners, this draft instrument? And my personal feeling in the early days when CMI working group was still working on the Beijing draft, and also in the, I would say, the early days, the early activity of the UNCITRAL working group, there was quite a lot of skepticism within the shipowning community. And I think it had to do a lot with perception, because judicial sale means a forced sale, means that we ship owners, our ships are being taken away from us forcibly. So that was not causing a lot of sympathy in shipowning circles. Same thing with the selling ship owner. The selling ship owner is generally referred to as the defaulting ship owner because he cannot pay his debts, and that's why in the first place we have a judicial sale. Another aim of the draft instrument was securing of claims against ship owners. So a lot of people had the feeling that the draft instrument was going straight against the interest of ship owners. All the more because some of the goals also were related to limiting the remedies for challenging the validity of a judicial sale. So the ship owner says, not only is my ship being judicially sold, they're also taking away my means of defense and my remedies for challenging the validity of the sale. And then finally, after a judicial sale, the ship should be cleansed from all rights from the past, which was an objection for the ship owner, the purchaser, who is buying the ship from a judicial sale. So that were some of the reasons why there was a lot of skepticism against the activities of CMI and UNCITRAL. Now, I think ship owners cannot stand on the sideline and simply watch the developments and see this instrument coming into life or into existence, because ship owners are central to the topic of judicial sale. Well, as mentioned before, first of all, there must be a defaulting ship owner, an old ship owner whose ship is being sold. And there, of course, the shipowning community cannot remain passive, and they actively have to participate into the genesis of this draft instrument, because the rights of the old shipowner, his rights of defense, the rules of due process, they are to be safeguarded. And that's why for ICS and BIMCO, all the provisions in the draft instrument which have to do with notification of judicial sale, the grounds for challenging judicial sales, suspension, and the cases where the judicial sales cannot have effect. So the ship owner whose ship is being sold is at the beginning of the whole story of the judicial sale, in fact. Then, of course, the party who buys the ship from a judicial sale, if he was not a ship owner yet to start with, he de facto becomes a ship owner by the fact of purchasing the ship in the judicial sale. And same for him. There are a number of concerns, especially legal certainty, as I mentioned before, in the form of legal title, ability to register the ship in the flag state of his choice as well. Those are crucial elements. And that's why, from that perspective, shipowning community pays special attention to the clean title provisions, the re-registration of ships, lifting of arrests, and provisions in connection with that. Then there is also a third angle to the judicial sale from the shipowning perspective. It's perhaps less obvious for those who are not involved in shipowning industry from day to day. But the shipowner is also a creditor, especially in these days where economies of scale are very important. Just look at the liner industry, where you have big consortia of liner shipping companies, where you have vessel sharing agreements, charter agreements. There are all forms of cooperation. Also in the dry bulk, where you have dry bulk pools. Also in gas shipping, you have gas pools. So shipowners are cooperating with each other all the time. And of course, it happens every once in a while that there's a weak part in the chain that breaks, and one shipowner has to claim from another shipowner. And from my personal experience, working as in-house lawyer in a shipping company, this happens quite a lot in recent days, especially after the financial crisis in 2008. And we are yet to see the impact of the current pandemic. Certainly there will be victims, and ship owners will have to claim from other ship owners. And then, of course, it's all a matter of trying to obtain a dividend payout after the vessel has been judicially sold. The vessel of your counterparty has been judicially sold, and you, of course, ship owner, we want to see the proceeds of the sale. We want to see it maximized. We want to see a great revenue. So even though this might seem to be a contradiction to some of you or some of the shipping lawyers, but we as ship owners, we arrest ships as well from time to time from this perspective. So I think the conclusion is that the ship owners, in fact, are the alpha and the omega of the whole story of judicial sales. It's a ship that's being sold, somebody buys a ship, and then, of course, we want to see the revenue maximized for various reasons. So that's why as ship owners, we take an active and participative role in the work of UNCITRAL. Now, you might think that there are a lot of opposed interests in a judicial sale. On the one hand, you have the ship finance banks. After the financial crisis, there are more and more ship leasing houses, and there's a lot of initially there were the JOLCOs, the Japanese operational lease and charter backs. You have a lot of big Chinese leasing houses these days. So you have on the one hand the ship financiers in the forms of the banks and the leasing houses. We have the ship owners themselves, of course. We have the crew, and we will hear in the next presentation that there's an important angle to judicial sale from the point of view from the crew as well. But then you have all maritime service providers, going from stevedores, terminal operators, ship chandlers, you name it. There's a myriad of service providers who have an interest as well. At first sight, it might seem that these interests are opposed, but on the other hand, and especially from the point of view from ship owners, I think all these interests converge in the end, because ship owners, for trading the vessels, chartering them out, carrying cargo under bills of lading, They need legal certainty, and they want to make sure that the vessel can trade from one port to another without arrests for previous claims. On the other hand, we as ship owners, the ships are becoming bigger and bigger, as I said, because of the economies of scale. Whereas, let's say 15, 20 years ago, a big liner vessel was 4,000, 5,000 TEU. The big liner ships these days, they are 5 to 6 times that size. So there are huge capital investments involved in ship owning. So we need optimal ship financing. So the interests of the ship financiers, whether they are banks or leasing houses, they are in fact also the interests of the ship owners. Same goes for insurance cover. Ship owners, there are huge capitals, the liabilities, the risks are huge. Just think of sinking of a vessel. The value of the ship is very high. Think of oil pollution, where the damages and the damage claims can run into tens of millions of dollars. So we also need to keep the insurance risks manageable. Of course, if a ship is purchased from a judicial sale and it runs fully laden with cargo from one arrest in port A to another arrest in port B because of claims relating to the vessel prior to the judicial sale, then of course the interest premiums of ship owners will rocket sky high. So there as well, there is a converging interest. And then of course for all the parties, crews, our crew members, of course, they make the ships sail the world seas and they make the world economy going. As we heard this morning, more than 18% of world trade is by sea. So even though at first sight there might be a post-interest between a terminal operator and a ship owner, ship agent, ship handler, ship chandler, but in the end, these are all parties which are providing services to our ships, and they ensure that our ships can sail the world seas and make the world economy turn. So I think rather than opposed interests, there are common interests. The ultimate goal of ship owners and all the other players is to facilitate the world trade, as I mentioned. And this is the reason why I'm telling all this. It's because I believe, and I'm actually convinced, that the draft instrument cannot be looked at solely from the point of view of the banks who want to maximize their profit, or maximize, I would say, their recovery in the event of a judicial sale. Not only from the point of view of a ship owner whose ship is being sold against his will, his rights need to be protected. So I think all these interests in fact converge, and that's why the draft instrument should be a really and truly balanced instrument, taking into account the rights of all parties involved and without any biases in there. So when we as ship owners are looking at this draft instrument and we are giving comment, it's not only from the point of view of the ship owner whose ship is being sold and that we want to shift and tilt the balance completely to the protection of the rights of this outgoing ship owner, and that we still want to include as many grounds for challenging or suspending the effects of the legal sale. That's not the case, because on at the same time we are the buying ship owner, so we have to strike a fair balance there between all those interests. Okay. So as I said, it's important to strike the balance between all those interests, and here I give a brief overview of the most important provisions in the draft instrument from the point of view of the ship owner. So first of all, it's Article 4, which has to do with the notification of the judicial sale. It ties in with the concerns of due process, rights of defense of the outgoing ship owner. And there, it is important to see, and we can only applaud, that a lot of improvements have been made in the 36th session in Vienna of the UNCITRAL working group, that the rights of the ship owner for the time being of the vessel, that his rights are protected by proper notice to be given to him. Also good to see that the law of the state of the judicial sale has an important role there, because the ship owner whose ship is being sold, of course, is involved in those proceedings. and he is aware of what's going on, and that will also be the forum where he will, in the first instance, invoke his remedies before the court there when a ship is being sold. We're also happy to see that there are a number of minimum requirements with respect to notification, which have been included in Appendix 1 to the draft instrument. The publicity via the repository is also something that ship owners can upload. Suggestions have been made that IMO would be running or keeping the repository. As ship owners, we are very familiar with IMO because we have a constant interrelation with IMO. We know them well. We also know that they run other repositories for other purposes. So that's something that we are prepared to consider. It's an independent, internationally recognized institution. So that might be an option there in as much as the repository is concerned. We also saw that there are provisions, dealing with the proper determination and safeguards with respect to the determination of the identity and the address of the parties to be notified. Indeed, to do, and again to do with the due process and rights of defense arguments. Then we move on to Article 9. Well, Articles 9 and 10, and these have indeed been extensively covered already in Goran Stankovic's presentation. I just want to mention and point very briefly to the fact that Article 9 is very important for the purchaser, so for the acquiring ship owner, and also for the outgoing ship owner, of course. It's good to see that there is exclusive jurisdiction for the state of the judicial sale, and for the reasons which I mentioned a few instances ago, and that domestic law has a role to play there. We also believe that if these issues would be dealt with in the draft instrument, it would be very difficult to reconcile all the national points of view. So we are happy with domestic law dealing. Domestic law meaning the law of the state of judicial sale, dealing with those issues, and that indeed is the forum in which the outgoing ship owner, if we can name it like that, will be dealing with. Same for Article 10, the circumstances in which judicial sale has no international effect. So we think indeed it's important criterion that the ship has to be physically in a jurisdiction. I think that's of utmost importance. And then, of course, the grounds for challenging and invoking the suspension, the grounds of public policy and fraud, of course, are of great importance, because if there is fraud involved, of course, in judicial sale of the defaulting ship owner, then his rights need to be protected as well, of course. And we were also happy to see that the circle of persons who are entitled to invoke the remedies of Article 10, that they include the owner of the ship immediately prior to the judicial sale. So we're happy to see that the rights of defense are covered there. What's also interesting, and provisions which have retained special attention from shipowning community, is the definition of clean title in Article 2. We know that it's an ongoing discussion and that there will be further deliberation in the further sessions of the UNCITRAL working group. There is some possible tension between what was initially in the Beijing draft and what is mentioned in the UN Convention with respect to international recognition of the rights of aircraft. It's a convention that was already referred to by Harman this morning, and especially in the field of extinction of any pre-existing rights and interests and any mortgage or hypothec or charge ceasing to attach to the ship. We'll follow that discussion with great interest in the further sessions of the working group. Article 6, of course, the international effects of a judicial sale. The effect is to confer a clean title. Article 6, of course, has to be read together with Article 3.1 and the limitation of the scope to judicial sales which are conferring a domestic clean title, which we think will take away a great lot of discussion under Article 10. If it's only domestic clean titles, that fall within the scope of the instrument. That's a good thing as well. Article 7, that's Merlis part of the action. So that's when a ship owner buys a ship from the judicial sale, he has to be able to do his work properly. And there, of course, the pressure lies with the ship owner, the purchaser who buys the ship, because it's up to him. It's the ship owner who requests the registry to register the ship. And of course, it's up to him to produce the documents to the ship registry. And that's where we find a great difficulty these days, and these days, I mean, in the absence of international uniformity. Then, last but not least, Article 8, of course, no arrest of the ship. So the applications, so the draft instrument provides for applications to arrest that they have to be dismissed after the judicial sale, and that the ship has to be released. No need to reiterate that the free trading of the vessel on the world seas is required to make the international economy work, and also, of course, for the ship owner to make his very expensive asset to make it earn its keep. Good. So that's why you have to strike a balance in this draft instrument, a balance between all the interests involved and not just the ship owner's interest, because indirectly the other interests, banks and all the other players, as I said, are indirectly also the ship owner's interests. So that's why we want to strive towards legal security, which also implies higher sale proceeds. And this is the perspective from the ship owner creditor, one ship owner claiming from another. And there, of course, the international disparity and the legal uncertainty, as I said, they lead actually to a destruction of asset value. We try to gain information from ship brokers, and we got some very useful information from one of the biggest, I would say, the top two ship brokers internationally, Laurijssen. And they said that they see per year only two to three auctions per year. And in a good year, they see up to a maximum of 6. So if Rob together, let's say with Clarkson's Plateau and with Maersk Broker, for instance, let's say if, presumably they are the top 3 of ship brokers around the world. So in a good year, if we multiply 6 by 3, then the top 3 ship brokers would only see something like 25 public auctions per year, whilst we have heard from Laurijssen that there are hundreds of ship auctions per year. And I was happy to hear from Merle Stilkenbaumer this afternoon that at Lisker alone, they see a couple of hundred public auctions per year, which confirms indeed the data and the information which I have received. This also means that there is very little attraction to the public, to potential and interested buyers to judicial sales. Judicial sales, according to information from Rob, take place mainly in South Africa, Aruba, Panama, Gibraltar, the Netherlands, not to name places like Malta, and where we hear that there are quite a few judicial sales as well. We also hear from brokers that in normal markets, that means when it's not especially seller's market, where of course there are upwards tendencies in the sale values of the vessels, but in normal markets, the price differential between market price and the revenue by a ship in a judicial sale is huge. They are very large, and there are also reasons why brokers shy away from judicial sales. It's because in general they don't earn a commission. You might say, okay, why do they have to think about their own personal interests? Of course, everybody has to play his role in the whole picture. And if through the use of brokers, wider attraction and wider publicity can be given to judicial sales, there will be more interest, and the auction prices will tend to be higher as well. There are also very practical reasons which are raised by brokers. They refer to documentation in clause 9 of the Norwegian sale form, which is one of the sale forms which are most commonly used. And from time to time, we see that court bailiffs refer to them as well in judicial sales. It stipulates that vessels should be free of mortgages, charges, and encumbrances. And that, of course, is the crux of the matter here, where we are looking for clean title and unencumbered sale of vessels. So that a bit as a side note from what we hear from brokers and the wider market for sale of vessels and public auctions compared to private auctions. Very recently in Tradewinds newspaper, it's a daily newspaper, only 2 weeks ago, 3 weeks ago, 17th of August, there was a striking article that was had to do with the sale of a multi-purpose vessel in Cape Town by the local court there. It was striking in the title. It said only 2 bidders took part in the auction of the vessel Ekarma on 13th of August. 2 bidders only. And the title continues saying, Turkish buyer submits winning bid at poorly attended multi-purpose vessel auction. And as you can see, the asset price was record low, and there were only 2 interested parties for a fairly recently built vessel, which was in relatively good shape. And that is a perfect illustration of what I've called before destruction of value. Because of course the ship owners, they buy the ship, they pay for the ship, they have ship finance by the bankers in place, and when a ship has to be sold at these type of record low prices, there's no different name for it than destruction of value. And that's what we want to prevent as ship owners, whether we are the ship owner whose ship is being sold, because on basis of the revenue the bank has to be repaid, and the remainder of the outstanding debt, of course, will have to be paid by the outgoing ship owner. Same for the ship owner creditor who wants to recover his debts from the ship owner whose ship is being sold. If the sale price, the auction price is 3 times nothing, there will be nothing to recover for the creditor ship owner whose claims are mostly non-privileged. So as ship owners, we have made a SWOT analysis of also of the model law versus the convention. We do not, as ICS and BIMCO, we do not have a final and firm viewpoint there, but I would say we have a legal committee of the members of ICS next Monday, September, where the issue will also be on the table. And some of the factors that will be considered there is the reciprocity between states, because of course, and it was also explained very nicely by Angelo this morning, the model law is a very, I would say, is a more loose structure and offers less guarantees for uniformity than a convention. In fact, we could say that a model law is an invitation to states to start meddling and to start changing the instrument, which of course is not ideal, whilst a convention is more a take it or leave it. But then of course we have the risk of insufficient number of ratifications. But reciprocity is a key word here, I think, in the whole discussion, because as ship owners, we are very much afraid of the so-called rogue states. These are states, I would say, the cowboy nations, where ships are being sold by court bailiffs or other instances at the snap of a finger. And the consequence, of course, will be that the good states who follow all the rules through the convention and the obligation to recognize the foreign judicial sale in a rogue state will have to be recognized by the good states and by the good ship owners whose ships might be sold in, I would say, Mickey Mouse jurisdictions. So reciprocity is very important there, because if you work with a model law, some nations might completely water down the instrument. And then, of course, the reciprocity and the level playing field is completely lost. That will be one of the elements of consideration in the ICS legal committee meeting next week. Of course, so that would be, those would be arguments pro ratification, but then of course we have the ghost wandering around, the ghost of the insufficient number of ratifications, and Angelo has already given or referred to the very sad example of the Rotterdam rules a couple of years ago, which are still dead letter. So I would say that's in a nutshell, and I didn't want to go too much into the legal detail of the different provisions which are of a major importance to the ship owners. And I was happy to see that that has been done by some of the other speakers already today. So that's those are in a nutshell the concerns of the ship owners. Our very general conclusion is that the draft instrument, whatever form it will take, it has to be truly unbiased. For the two, I would say the two red threads which ran throughout my presentation, that is, all interests involved in a judicial sale, buyer, seller, banks, service providers, are in fact, and at least indirectly, the interests of the ship owner. So it has to be a balanced document without any biases. And moreover, from the point of view, if we would come to the conclusion, and if the International Working Group would decide that the form of the instrument is a convention rather than a model law, then of course there can't be any biases, because the least bias will cause states to refrain from ratifying the instrument. Well, that's in a nutshell what I had to say from the ship owner's perspective. I thank you for your attention, and we'll try to pass the word back to the chair.
Thank you very much, Peter.